Hello and welcome to another edition of Coffee Talk with Immigration Attorney Brian D. Lerner. We're talking about U visas. Now, what happens if the U applicant refused to provide assistance or some assistance that was asked for? Because that is a requirement generally to get the U visa. Is it possible to still get it even though the assistance wasn't provided? Well, the answer is yes. If the U applicant refuses to provide assistance, then the Attorney General will determine if it was unreasonable under the totality of the circumstances based upon all of the available evidence at the time. So the Attorney General can take into account such factors as general law enforcement, prosecutorial and judicial practices, the kinds of assistance that was asked of other victims of crimes involving an element of force, coercion, or fraud. The Attorney General can also look into the nature of the request, the nature of the victimization, and existing guidelines for victims and witness assistance, and specific circumstances of the applicant, including fears, severe mental and physical traumatization, age, and maturity. So there are a lot of different ways that the applicant can essentially avoid having to give assistance, or maybe they gave some assistance but didn't go all the way. So just because of that, that's not a ground to deny the U visa, and there are ways of submitting evidence to show that that person still qualifies for the U visa under the circumstances.